You are listening to Based in Fact, a true crime podcast. Join host Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to Season 3 of Based in Fact, a true crime podcast. We're your hosts, Lisa O'Brien and Kyle Evans, and this is Episode 11, State of Texas versus Linda Anita Carty. In Part 1, we'll look at the May 2001 plot hatched by Carty to save her common-law marriage by stealing her neighbor Joana Rodriguez's baby. She recruited drug dealers' thugs to commit a home invasion, promising them of large cash of drugs and money. She also made preparations to take the baby from Joanna's womb or to steal him from a hospital. Carty, a compulsive liar, couldn't keep her mouth shut, and after Joanna and her newborn son were kidnapped, a neighbor who saw Carty at the complex the night of the kidnapping pointed police in her direction. Joanna's body was found in the trunk of a car rented for Carty by her daughter, and Joanna's newborn son, Ray, was found in the daughter's car, thankfully unharmed. We'll talk about the evidence against Carty, her 2002 conviction for capital murder and death sentence, her direct appeal, and her initial post-conviction claims in this episode. And welcome back, Kyle.
Good afternoon. How are you? Thank you. Welcome back.
Pretty good. Yeah, I wanted to record last week, but Rob Chadwick was going to sit in with me for you, and then he was ill. So we're hoping him the best and hope he's feeling better. And we will do another episode with him sometime down the road. So how was your time off?
It was good. Did a long road trip, but it was good. And now just back for the feels like to date has been a pretty nice summer, all things considered, but summer has definitely arrived in Texas now in August. So it has been a little bit warm after having actually been a pretty nice summer. So hopefully it's not going to stay this way through October.
I know. It's the same here. I'm having to turn my air conditioner off because it just keeps running if I don't. So I have to turn it off and then turn it back on, and it's just crazy. All right, so let's get started. We do have a lot to go over because this case requires a little bit more information than some others. Of course, we'll start with the victim in this case. And there were actually multiple victims, but in this case, because I don't know a lot about any of them, I just focused on Joana Rodriguez. She is the victim who lost her life. She was born around 1980 or 1981 in Guanajuato State, Mexico. Now, we don't know anything about Joanna or her background because this case, while it started at the time the internet was just popping off, there just isn't a lot of information about her. The first known human settlement in Guanajuato existed between 500 and 200 BC near Chupiquaro. Guanajuato was founded in 1554 by the Spanish and given city status in 1741. Along with Zacatecas, Mexico to the north, and Potosi, Bolivia, the town became one of the three greatest silver mining centers of the 16th century.
Oh, wow.
Its celebrated Veta Madre, Mother Lode, was described as the richest in the world. The free and sovereign state of Guanajuato is a landlocked state in the center of the Mexican Republic. It shares borders with San Luis Potosi and Zacatecas on the north and Querétaro on the east, the state of Mexico on the southeast, Jalisco on the west, and Michoacan in the south. And I am sorry that my high school and college Spanish is totally gone, and my pronunciation was deplorable. My apologies. Now, one of the things that we can start off right now, Joanna was Hispanic. She was not Caucasian. She was not white. She was Hispanic, making her brown. Linda Carty's advocates have described her as a white woman, which is to make it seem like there is some racial disparity with Carty's conviction and sentence. That is untrue. Her parents, her father was Raymond Rodriguez. She has a sister, Erica Rodriguez. Don't know anything more about her mother or other siblings. We don't know anything about her education. She was working for a water purification company in Texas. She married Raimundo Cabrera in 1999, and they moved from Mexico to the United States. They'd grown up in Guanajuato together. She had a son, Ray, born on May 12th, 2001, and her cause of death was suffocation or positional asphyxia. It could have been either. The perpetrator in this case is Linda Anita Carty, and of course, totally ridiculous that we know as much as we know about her and not anything about her victim. She was born October 5th, 1958 in St. Kitts and Nevis in the Leeward Islands, Lesser Antilles, and it's the British West Indies, not Virgin Islands. Her father was Alfred Carty. Her mother was Enid Carty, who also goes by the name Enid Webster. She has 6 siblings, Boyce, Sonia, Verna, Eastland, Yvette, and Clarence. No particular birth order for them. I don't know what order they were born in or anything like that. She has high school and some community college and college education in pharmacology. She was a teacher at one time in St. Kitts, but she moved to the United States in the early 1980s. She had a common law marriage to Jose Javier Corona, who was born June 6, 1970. So she's 12 years older than he is.
Oh, wow.
She had a daughter out of wedlock, Jovel Carty, who goes by the last name Joubert now, who was born in September 1979. Her father allegedly was a police officer, and he lives somewhere in the United States as well now. But they did not marry her or have anything more than a brief relationship that resulted in pregnancy. Emotionally, mentally, she's a compulsive liar. She's a con artist. She's manipulative, and she has delusions of grandeur. Her prior crimes include theft on August 3rd, 1983, auto theft, where she impersonated a federal agent to steal a rental car valued between $750 and $20,000. That was on August 31st, 1992. That may have been the reason that she was let go by the DEA as an informant. She has probably a couple of drug arrests that disappeared because she became an informant. She had possession of marijuana, 5 to 50 pounds, and aggravated robbery on January 24th, 1994. Those charges were dismissed. That may be when she became an informant for the Houston Police Department and or DA's office, Harris County DA, and then unauthorized use of a vehicle in November 24th, 1998. That was also a theft of a vehicle from a rental car agency. Her accomplices in this case, who we're not going to talk a whole lot about, but we're going to talk about them a little bit, are Chris Robinson, Carlos Williams, Gerald Anderson, and Zebediah Coombe. They were all charged in connection with this case. She also had 2 additional uncharged accomplices, and they are Marvin Caston and a woman named Josie Anderson, who was the girlfriend of one of her charged co-defendants. The victim again was Joana Rodriguez, age 20. Ray Cabrera, aged 4 days, Raimundo Cabrera, aged 28, and Rigoberto Cardenas, whose age is unknown.
Was he a
He was
child or?
No, he was an adult. He was Raimundo's cousin. He was staying with Joanna and Raimundo in their apartment and was sleeping downstairs on their couch when this occurred. And he was
Do,
beaten and tied up and a victim of this armed robbery home invasion.
do we know how she knew the her accomplices? Were they just acquaintances?
They were drug dealers and thugs that she probably knew from running in the drug world. She recruited them. I think she recruited them through Josie Anderson. I didn't go into a whole lot of that background in the background because it is somewhat complicated. But she recruited them. They were in the drug world. She, recruited them through Josie Anderson, told them she knew a drug dealer that had a lot of money and drugs in his apartment, just had a big delivery of, like 1,000 pounds of marijuana. And so they were interested in drugs and money and an easy robbery that the victim will not report to police. That's what they thought. The crimes occurred at 1030 Westview, number 36 in Houston, Texas, which was an apartment complex. Carty had lived in this apartment complex, but had recently moved out after her common law husband left her for the final time. And then 6042 Van Zant, also in Houston, Texas, and all of this is located in Harris County, Texas. Joanna and her husband Raimundo moved to Houston, Texas shortly after their marriage in 1999. They each worked and made a home in an apartment in Houston. In the spring of 2001, Joanna was expecting the couple's first child. What they didn't know was that one of their neighbors, a con artist, an ineffective criminal with a sketchy history as a DEA informant, coveted their child to keep her common law husband, Jose Corona, from leaving her. Carty, who continues to claim she was an active CI with the DEA and or Houston Police Department, had not worked with either agency as a confidential informant since 1994-1995, 6 to 7 years prior to the 2001 robbery, kidnapping, and murder of Joana Rodriguez. She was deactivated by the DEA because she'd been placed on a 10-year adjudicated probation in state court, and she was deactivated by Houston PD or the Harris County DA's office because she'd led police on a car chase when she was in possession of drugs, which violated her contract. Carty soon began telling Jose and other neighbors that she was pregnant. No one believed her. Linda's relationship with the truth was non-existent. Corona testified that Carty had told him she was pregnant many times and never produced a child, so he believed this time was no different. She also claimed to have had miscarriages, but there was something I read years ago, and I couldn't find it in my research this time. She had actually had her tubes tied. And it was in the early 80s when it was not reversible. It was permanent. So, but I couldn't find that when I was doing this research, so that may or may not be accurate. What the people around her didn't know was that Linda had hatched a plan to steal Joanna's baby and keep it as her own. She gathered baby supplies to care for the child, medical supplies, and a nurse's uniform to take the baby from his mother's womb or steal him from a hospital. She also recruited petty criminals Chris Robinson, Carlos Williams, Marvin Caston, and Gerald Anderson to commit a robbery at Raimundo and Joanna's apartment. Carty lied to them by telling them the apartment belonged to a drug dealer with a large cache of money and drugs. Carty took other steps to implement her plan, including reporting to Houston police that she'd been accosted in the complex parking lot by two Hispanic men with guns. The report, needless to say, was false. She showed her former apartment to Robinson, Williams, and Anderson so they could familiarize themselves with the layout of Joanna and Raimundo's apartment. When Corona left her for good in early May, Carty moved out of the apartment. Neighbors, however, saw her hanging around in the parking lot outside Joanna and Raimundo's apartment on May 15, 2001. Carty told one of those neighbors that she was due to have her baby the following day, May 16, 2001. She'd also told a clerk at a local storage facility that she was in labor, and on a later visit that she had a baby boy who was at home with his father. She told Zebediah Coombs, Robinson's half-brother, that Joanna and Corona had an affair and the baby was Corona's child. She also told Coombs that she would cut the baby out of the bitch. On May 12, 2001, Joanna gave birth to a healthy baby boy. She returned home on May 13, 2001 with her baby, who she'd named Ray. On the night of May 15, 2001, she, Raimundo, and Ray went to sleep in their bedroom on the second floor of their townhouse. They had no idea what was about to happen to them. At around 1 a.m. on May 16th, Robinson, Anderson, and Williams kicked in the door of number 36, bound everyone's hands and feet with duct tape, and assaulted Raimundo and Rigoberto. They demanded drugs and money and ransacked the townhouse. There were no drugs, but they took approximately $1,000 that Raimundo and Joanna had been saving to buy a car. Anderson called Linda from inside the apartment and was told to bring the lady and the baby to her. Linda was waiting for them in the parking lot with two cars, a gold Pontiac Sunfire rented by her daughter Jovel and her daughter's black Chevy Cavalier. Ray was put in the car seat in the Cavalier, and Joanna was placed in the trunk of the Sunfire. The two vehicles were then driven to a house on 6042 Van Zant in North Houston. Her accomplices were angry that they'd gotten no drugs and money in the robbery and directed their anger toward Carty, who promised them another lick that would pay them off. And they even discussed killing Carty, which unfortunately they didn't do. Coombe, who lived in the house with his grandmother.
So do you think she knew that? Did she think she knew there wasn't going to be any drugs there and she was running a scam on them?
Oh, yeah, she knew. She knew. She's a con artist. She's a scammer. She's gone into a rental agency, said, I'm a federal agent. I need a car. Give it to me. And shown false credentials and driven off in the rental agency's car. She's told people she's a confidential CI when she's not and hasn't been for years. Yeah, she's just a con artist. She knew there was no drugs or money. She wanted the baby, but she didn't want to go into the apartment and get the baby. She wanted to send somebody in the apartment to get the baby for her. And they brought Joanna. And she may not have realized at that time that Joanna had the baby. She's not smart either. I mean, average intelligence, I would say not even that close. Anyway, so Zebediah Coombe, who lived in the house with his grandmother, came out to quiet the group because they were getting loud. Carty wanted to move Joanna to the trunk of his Cadillac, and he refused. Coombe told them to leave, but before they did, Carty had Robinson tape up Joanna's arms and legs and place tape over her mouth and leave her in the trunk of the Sunfire in May in Houston, which probably would not have been comfortable at all. Robinson, Anderson, and Williams left, but Carty did not. When Robinson returned, he saw Carty leaning inside the trunk and found a plastic bag taped over Joanna's head. Joanna was dead. Robinson agreed to drive Carty and the baby to a motel where she was renting a room. They left the Sunfire at the Van Zant house and returned later with the baby, where Coombe saw them standing at the open trunk of the Sunfire. Coombe told them they had to get the car away from his grandmother's house and refused to help Carty dispose of Joanna's body. While investigating the robbery on Westview, neighbors reported Carty's presence at the complex that day and her claims about her pregnancy and the impending birth of a child. This led investigators to focus on Carty, who agreed to come into the station for questioning. Robinson and Anderson went back to the Van Zandt house where they put Ray in the Cavalier and wiped down both cars to get rid of fingerprints. Carty had planned a second drug theft and left Van Zandt with the baby. Anderson and Robinson to carry it out. The Sunfire was again left at the Van Zandt house, and it's kind of the details are kind of confusing, as you can see, because I did get a little confused. She got the call while they were going to do the second lick, and the police had the perfect reason to con her into coming to visit them because she had reported being accosted by two Hispanic men. Carty left Ray with Robinson and arranged for a ride to McDonald's where she met detectives. She agreed to return to the apartment complex with them, then rode with them back to the homicide office. Carty claimed she was working for the DEA and asked to speak to her handler, Charlie Mathis. When Mathis came, Carty denied being involved in the robbery and kidnapping and claimed to have lent her car to a drug dealer who threatened to shoot her. During Mathis's interview, she continued to deny involvement and failed to answer several direct questions from him. She did the same with Corona when he came, and later when she was interviewed by detectives. It was all about Carty avoiding responsibility. Later, Carty claimed she'd loaned her car to a man named Carlos, and she also would later ask a cellmate to write a confession letter from a man named Oscar, which would exonerate Carty of guilt. Robinson and Coombs were not trying to avoid responsibility for their actions. Coombs hadn't been involved in the robbery, the kidnapping, or murder, but he was candid about Linda Carty's actions, statements, and it was clear that she was the one in charge. Robinson was also candid and even admitted that Carty had fooled him into believing that the Rodriguez Cabrera apartment held a cache of drugs and money. He saw Carty leaning into the trunk of the Sunfire and saw that Joanna, who had a plastic bag covering her head, was dead. He told investigators that Carty was an evil woman.
I apologize to the audience as I'll go ahead and put on my Captain Obvious uniform. And I mean, I realize the average criminal isn't going to be the president of the local Houston Mensa Society, but I'm just constantly just amazed at these people that are like, oh yeah, I'll go rob and kill somebody because some crazy woman told me to. Like, I'm not excusing it anyway, so like I don't want people to take the thing to like, oh, sometimes it's fine. But it's like, oh yeah, I'll totally risk, going to jail or the death penalty because some dingbat woman, encouraged me to do it. I mean, I don't know. I'm constantly amazed by stupid criminals. I know it's Captain Obvious. I'm without speech. I'm speechless without speech with these people.
I think that something that logical, reasonable people forget is that criminals do not consider the consequences of their actions. They always think that they're going to get away. And with Linda Carty, she was even more calculated to a degree because she chose people that she could say are framing her.
And I mean, I'm gonna dig a hole like even deeper, so I apologize in advance. But like, I could sort of see like just a beautiful, gorgeous woman or super striking, charming man that can trick people into doing things for them. But like, I wouldn't believe this woman? Like, if she told me the sky was blue, I would verify.
Yeah. And if you shook her hand, you would check to make sure all your rings.
Yeah, like, I just don't understand why these guys would like do anything that this woman suggested. I kind of feel bad for them. Like, I mean, they're evil people. They got what they deserve, but I have some level of sympathy that they're just so stupid that they, fall for this crap.
Yeah. Yeah. Well, yeah, I don't understand why they believed her, but again, they don't consider that they're going to get caught.
Yeah.
But I have to say, Anderson Robinson and Williams, they were candid about their involvement. Now, I don't think Anderson and Williams wanted to testify, but Robinson did. So, but we'll get to that later. Eventually, Carty agreed to bring police to a location where she thought the men who had her car hung out. There, police found the Cavalier with Ray inside, thankfully unharmed. They also found the Sunfire with Joanna's body in the trunk. Robinson was there, and he too was arrested. He was later identified by Raimundo and Rigoberto. They also arrested Coombe, who lived at the Van Zant house and was on house arrest while awaiting trial on federal charges. In the house, they found Carty's gun stashed in a dresser in Coombe's bedroom. And when they checked Carty's phone records, they found that 11 calls had been placed between Carty's phone and Anderson's phone on May 16th. There were a total of 7 calls between 1:09 a.m. and 1:14 a.m., which is the time of the home invasion. Anderson and Williams were subsequently identified, and each of them was arrested in July. So that's the kind of the framework of the crime. Carty was arrested on May 16, 2001 by the Houston Police Department. A complaint was filed on May 17, 2001, charging her with capital murder in docket number 877592 of the 177th District Court in Harris County, Texas. A complaint was also filed against Chris Anthony Robinson and Zebediah Coombe, charging each of them with capital murder, and their docket numbers were 877593 and 877594. On May 17th, Carty appeared before a magistrate and received a statutory warning by the magistrate, who set no bond and remanded her to custody at Houston Sheriff. Now, on the form, she is noted to be a U.S. citizen. It says nothing about her being a British citizen. It says nothing about her being a citizen of the independent island of St. Kitts and Nevis. On May 21st, she has another statutory warning by the magistrate. It's called probable cause and statutory warning on the Harris County records. And that is signed by Carty. It sets no bail. It includes a statement that per defendant, she is a U.S. citizen. And it also includes the consular rights warning for foreign nationals, because Harris County is a very diverse county with a lot of people and a lot of people of different nationalities living there. Now, I want to say this right now, because for anybody that's not obvious or logical or reasonable, your citizenship of whatever nationality or country you claim is a fact that is not obvious to those talking to you or looking at you. And it's a fact really only known to you unless you also are carrying a passport at that time, which Linda Carty was not. So that is something you need to keep in mind. If the paperwork says Linda Carty is a U.S. citizen, it's because she told people that. And there's no other way they could have gotten that information. On May 30th, 2001, an attorney by the name of George Parnham, who some people may have heard of because he's kind of a big deal in Texas, he's represented a lot of very famous clients, he filed a notice of appearance. He was hired by Carty's family to represent her. Pre-trial, this was in the 177th District Court of Harris County, Texas. The judge was the Honorable Carol G. Davies. There's also apparently some paperwork that was signed by Doug Shaver, whose name some might recognize from Rodney Reed. And it's kind of confusing as to when he was involved and why he was involved. And later on, it'll get more confusing because Carty's attorneys apparently didn't know who the friggin' judge in her case was. But we'll talk about that later. So Parnham was initially counsel. She was arraigned. She pled not guilty on June 5th, 2001. He filed a motion for discovery and inspection on June 8th, 2001. And he asked for a whole laundry list of documents and things and evidence in this case right out of the gate. He also filed a motion to discover any and all existing agreements between the state and witnesses, also on June 8, 2001. And again, laundry list of things to gather information about the witnesses against Carty. On July 2nd, 2001, an order was entered granting the motion for discovery of agreement between the state and witnesses. So at that point, the state had to disclose any deals it was making with Chris Robinson, Zebediah Coombe, Gerald Anderson, or Carlos Williams. Well, Gerald Anderson, Carlos Williams hadn't been arrested yet, but between Robinson and Combs. On July 2nd, 2001, an order was also entered granting Carty a private meeting room at the Harris County Jail for attorney conferences. Felony indictment was entered on July 17, 2001, charging Carty with capital murder, and Chris Robinson was also charged on the same date by indictment with capital murder. On July 24, 2001, Carlos Way Williams Jr. and Gerald Jerome Anderson were arrested, and they were also charged by complaint with capital murder in docket numbers 0883055 and 0883056. On August 22nd, 2001, Carlos Ray Williams Jr. was indicted for capital murder, as was Gerald Jerome Anderson. On September 18, 2001, George Parnham filed a motion to withdraw. He was withdrawing because Carty was indigent and unable to employ an attorney of her choosing to represent her, and because he was representing Andrea Yates, and there were conflicts with Carty's case and her trial, which was set to be held in the 230th District Court in Harris County. So his request to withdraw was granted. On September 18th, Gerald Jerry Guerno was appointed to represent Carty. The state on October 12th filed a notice of intent to seek death penalty. On October 17th, 2001, the court also appointed attorney Wendy Akins to represent Carty as the second chair. On October 23rd, 2001, Guerno filed a motion to suppress illegally obtained evidence, arguing that Carty was arrested without a valid warrant and or probable cause, and in the absence of exigent circumstances, her statements were the fruit of an illegal search and seizure, and they should be suppressed, and that the search of her hotel room at the Hampton Inn was conducted without a warrant and without probable cause, and in the absence of exigent circumstances. So he was seeking to have all the evidence obtained, which was the bulk of the baby supplies and clothing from the Hampton Inn hotel, suppressed. He also filed a motion seeking discovery of punishment evidence on that same date. And again, he wanted a laundry list of information from the state. He filed a motion for discovery and inspection of evidence, again, seeking a laundry list. I listed the specific evidence because I listed the laundry list because Carty is claiming he was so horrible and ineffective he didn't do anything. But this shows he did do things. He filed motions. Granted, he wasn't successful in all of them, but he filed them. And they looked at specific, they were looking for specific information and putting the feet to the fire of the prosecution to prove its case. He sought motion for disclosure and production of exculpatory and mitigating evidence in the possession of the state. So he didn't sit on his hands and not do anything in Carty's defense. And this was from the moment he took the case that he did all these: motion for production of prior statements and witnesses before cross-examination, motion for identification hearing, motion for notice of intent to introduce punishment evidence, request for the jury to assess punishment, motion to record voir dire examination testimony and bench conferences and arguments during the trial. Discovery order was entered on November 12, 2001 by the court, and it granted some of Carty's various discovery requests, which were in accordance with laws and rules of procedure. She filed a motion to suppress oral and written statements on November 16, 2001. He filed a motion to prohibit assessment of the death penalty, challenging Texas death penalty statute as cruel and unusual punishment. That was denied. Of course, that's because that issue has been examined by the Court of Criminal Appeals, which is the highest criminal court in the state, and they found it to lack any merit.
Yeah, I think
That's
when
not
they were
his
talking
fault.
about cruel and unusual punishment, they were talking about drawing and quartering and things like that, not lethal
Right,
injection.
right. And well, he also challenged it on the way juries are instructed on mitigating and aggravating circumstances, and how they want the state to have to prove mitigating circumstances beyond a reasonable doubt. And that because the state isn't required to do that, you know, it's convoluted. Like, they want the state to do something the state is not supposed to have to do, but they want it to have that burden. Anyway, and they argue also that the state not having to prove mitigating circumstances, lessens their burden of proof on the aggravating circumstances. It's convoluted. I don't know. Maybe one day we'll look at that in more detail. He filed a motion to set aside the indictment, citing essentially the same reasons as those cited in the challenge to the assessment of the death penalty. He filed a motion for ex parte hearing for funds to hire a defense expert. He filed a motion for proof evident hearing. He challenged her being held without bond. And he actually got a bond hearing, and bond was set at $500,000. And he also sought supervision by Harris County Pretrial Services, although I don't think she ever actually made the bond. He filed a motion for community supervision, which was signed by Carty. Now, unfortunately, I don't think that Carty was honest. And I don't know whether he did not know who he was dealing with or whether he just let her say what she wanted to say. She had entered a deferred adjudication agreement and was put on 10 years probation for an 8/31/92 theft of a vehicle from a car rental service. So, and in 1999, there was an order adjudicating her guilty of that charge, although the and community supervision false. Then on November 29, 2001, the court entered orders granting the motion to record voir dire, etc., the motion for funds to hire for a defense expert, and motion for proof evident hearing due to setting a bond and conditions. So that was found to be moot, basically. On January 8, 2002, the motion to suppress oral and written statements was denied. Subsequent to her trial, findings of fact and conclusions of law were entered, um, basically supporting the denial of the motion to suppress. Um, and we'll get into that a little bit later. There was a hot meal order entered, so while she was being tried and being held during the day at the courthouse, the sheriff was ordered to provide her with a hot lunch because she claimed to need it. Um, she also she did a lot of letters to the court, and I just ignored them because they're all self-serving bullshit. But she did a lot of letters, and she's done a lot of letters over the years. We might look at those in part 2. On January 10th, uh, an order was entered granting the state's motion for disclosure of Carty's expert because they're entitled to know who her experts are and what they're going to testify to. On January 16th, the DA filed a notice of intention to use extraneous offenses and prior convictions, and those included the auto theft on August 31st, 1992, where she received the 10-year deferred adjudication probation, and a motion to adjudicate the pending case was now filed based on her commission of capital murder. Possession of marijuana and aggravated robbery on January 12th, 1994. An agreement with the DEA and Harris County DA entered on August 10th, 1993, which was abandoned on January 24th, 1994 due to her failure to honor the agreement, which was the aggravated robbery and possession of marijuana. Possession of marijuana and delivery on May 13th, 2001 and May 14th, 2001, because she had a pound of marijuana in the trunk and delivered a quarter of it to Marvin Cass. Defendant told the inmate to write that she had been set up by Zeb and Chris, who wanted to get back at Linda's brother, who worked for the DEA. That's false. She called Charlie Mathis her brother, but he wasn't really her brother. They set her up by putting the baby in the car that they borrowed from her. She further said that Oscar was in Mexico. And next week, we're going to talk a little bit more about the alternative suspects that have been identified over the years by Linda Carty. But right now, we're not gonna go down that little rabbit hole because it is deep, dark, and scary. Her trial was held in the 177th District Court in Harris County, Texas. Same docket
with hot
number.
meals.
With hot meals every day. Now, I have the Honorable Doug Shaver, and that's wrong. That was based on one of her direct appeal pleadings. I changed it back to Carol Davies, but obviously I missed it. The counsel for the state were Connie Spence and Craig Goodhart, and counsel for the accused were Gerard Garano, and Wendy Akins. There was a hearing on the motion to suppress oral and written statements on January 8th. Jury selection also went from January 8th or 9th to February 5th. On January 29th, the court entered findings of facts and conclusion of law supporting the denial of the motion to suppress. And I am going to go through those things because they provide evidence of the case against Carty, as well as they contradict a lot of her statements in the motion to suppress as well as later on. Carty voluntarily accompanied investigators to the Sandy Glen Apartments, consented to their search of her former apartment, apartment 38, and voluntarily accompanied them to the Homicide Division of Houston PD. Carty was in no way threatened or coerced to come to the police department to make a statement and was not placed in custody in any way. Carty was allowed to make several phone calls prior to and during the ride to the homicide office, and she told officers she was a CI working for the DEA, specifically working with with an agent named Charles Hayes or Charles Mathis. Carty was seated in an interview room at the homicide office and not handcuffed. She was free to leave at any time. Charles Mathis was called and came to the homicide office, where he spoke to Carty at great length in an interview that was videotaped. Toward the end of the interview, Carty states that she is planning to leave the country after all this mess is over with, and that is when she was placed under arrest. Once in custody, Carty directed officers to another location. Carty was taken to the Southeast Command Station and taken before Judge Jonates, where she was given her magistrate warnings at 8:45 a.m. on May 17, 2001. And that's when she said she was a U.S. citizen. Carty was advised of what offense she was charged with and signed a written copy of her warnings acknowledging that she received them. She was in custody when she was then returned to the homicide office. Personnel spoke with Carty and observed that she did not appear to be intoxicated or under the influence of narcotics. Carty agreed to give a formal statement. Prior to her statement, she was advised of her rights under Miranda. The legal warnings were recorded on the videotape of the interview. Carty did not invoke any of her rights. The state's witnesses are found to be truthful and credible. The conclusions reached by the judge were: the defendant was advised of her rights and the offense she was charged with by the magistrate prior to the taking of her statement. The defendant was in custody and was under interrogation at the time she gave her statement to Sergeant Shirley, making admission of the statement contingent upon compliance with Miranda. Defendant's second videotape statement is admissible as evidence against her because the statement is recorded on videotape. The face of the statement shows that the defendant was properly warned pursuant to Miranda. The defendant knowingly, intelligently, and voluntarily waived those rights before making the videotape statement, and at no time during the giving of the statement did the defendant invoke any of her rights. Finally, the statement was made freely and voluntarily without compulsion or persuasion, and the defendant was not in custody during the taking of the first videotape statement and was present freely and voluntarily without compulsion. First amended notice of intent to use extraneous offenses was filed on February 7th, 2002 by the state, and it added that Carty had pointed a gun in a threatening manner at Jose Corona on May 1st, 2001, when he left her. An order was entered on February 13th, granting Carty's motion to suppress evidence seized from Hampton Inn, room 402, pursuant to the manager's consent. Now, the guilt phase, innocence phase of her trial started on February 11th and ended on February 19th. And I do want to go through the testimony at her trial because it does, again, it shows her guilt and it contradicts a lot of the statements that we're going to hear about from her later post-conviction, as well as next part 2 when we talk about the conclusion of her post-conviction claims. Florence Myers told police about an encounter with the appellant that seemed suspicious. The appellant lived in apartment 38 and Myers lived in apartment 40. On the evening of May 15, 2001, Myers saw the appellant sitting in a car in the parking lot of the apartment complex. Myers identified the car as the same one that was later identified as the Pontiac Sunfire rented in the appellant's daughter's name. The appellant invited Myers to sit and visit with her. The appellant told Myers that she was pregnant and that the baby was going to be born the next day. There was an infant's car seat in the back seat. Myers testified the appellant did not appear to be pregnant. After the appellant was placed under arrest, she directed officers to a house at 6042 Van Zant Street. A black Chevrolet Cavalier belonging to the appellant's daughter, Joelle Carty, and a Tanner Gold Pontiac Sunfire rented in Jovelle's name were both parked at the house. The victim's baby was found alive in the Cavalier. The victim's body was found in the trunk of the Sunfire. Her arms and legs were bound with duct tape. Her mouth and nose were also taped, and she had a plastic bag over her head, which appeared to be taped around the bottom. The cause of death was determined to be homicidal suffocation. The appellant's fingerprints were found in both cars. Inside the cars, the officers found duct tape, nylon rope, Lysol spray, baby clothes, baby blankets, a diaper bag containing infant formula, and other baby paraphernalia. The diaper bag also contained a live round of ammunition of the type and size that could be fired from a 38 caliber gun. A 38 caliber gun was found by police in a drawer inside the house at 6042 Van Zant Street. And I'm betting that Linda Carty went in that house and planted the gun in Zeb Combs' drawer. But I'm only speculating about that. Jose
No, I
Corona.
think it's probably right. See,
Jose,
I bet that's 100% right.
yeah. Jose Corona testified that in the 2.5 to 3 years that he and the appellant had lived together, the appellant had told him 3 times that she was expecting a baby. In the first 2 instances, she eventually told him that she had miscarried. The appellant did not allow Corona to go with her to any prenatal doctor visits, and Corona believed the appellant had lied about the pregnancies. At the beginning of May 2001, Corona decided to leave the appellant. When he told her he was leaving, the appellant told him she was pregnant again. Corona did not believe her and moved out. The appellant continued to call Corona repeatedly throughout the month of May. She called him on May 15th and told him she was going to have a baby boy the next day. On May 16th, she called and told him she was going to have the baby that day. When Corona saw the appellant later that day at the police station, he asked her if the baby had been born already, and she told him not yet. Corona found out later that the appellant had never been pregnant. During the early part of May 2001, Corona saw the appellant in the possession of a gun that he identified as similar in appearance to the 38 caliber gun officers found at the house on Van Zant. Sherry Bancroft, an employee at Public Storage, testified that the appellant had an existing storage unit in their facility and rented a second one on May 10th. She had known the appellant for several months and saw nothing different about her appearance on that day. On May 12th, the appellant rented a third unit and told Bancroft that she was expecting a baby boy who would be born that day. She told Bancroft that she was already in labor. The appellant returned on May 15th around 6:30 p.m. and was there until at least 7:30 p.m. She told Bancroft that she had indeed had the baby and that he was at home with his father. She retrieved a baby blanket and 2 baby outfits from one of her units. Bancroft identified the car that the appellant was driving on the evening of May 15th as the Pontiac Sunfire. 2 additional witnesses testified that they knew appellant and she had told them in the days immediately before the offense that she was expecting a baby. The appellant's cell phone records led police to Gerald Baby G. Anderson, who eventually gave a statement and was charged with capital murder in this case. The appellant's cell phone records were introduced, reflecting 11 calls logged between 12:50 a.m. and 2:50 a.m. on May 16, 2001, between the appellant's phone and the cell phone number that led police to Anderson. 7 of those calls were placed between 1:09 and 1:14 a.m. Sarah Hernandez testified that she met the appellant when they were both serving time in jail. The appellant asked Hernandez to write a letter for her because the appellant did not want the letter to be in her own handwriting. The appellant wrote out what she wanted the letter to say, and Hernandez copied it. Hernandez said the letter was supposed to be from someone named Oscar. The letter said something about the appellant being set up by Chris and Zeb, who borrowed the appellant's car and put the baby in it. The letter stated they had a grudge against the appellant because she was black and because the appellant's brother, who was a DE agent, had busted them. Now, Robinson and Combs are both black, or Combe are both black. So is Gerald Anderson, so is Carlos Williams, so is Marvin Caston. Now, why would they have a grudge against Carty for being black?
Yeah, it doesn't matter though. The race card, like it can be played and all. Like it doesn't matter. Like it's just auto played at this point.
Mm-hmm.
I
So,
mean, it
but
doesn't matter because they're probably, they'll have some
that,
explanation.
yeah, that's just another example of why a lot of Cardi's statements and claims just don't make any sense.
Yeah.
The appellant's daughter, Jovelle, testified that she rented the Pontiac Sunfire at the appellant's request to assist in moving some of appellant's things to the storage unit. Jovelle also testified that in the last 3 years, the appellant miscarried 3 times and that baby items were purchased in anticipation of those babies. Jovelle was in Florida at the time of the offense, and the appellant had permission to drive her daughter's black Cavalier while she was gone. Now, why would she need to rent a car if she was going to be able to use the Cavalier? And why would you rent a Sunfire, which is a two-door car, rather than a station wagon or an SUV or a pickup truck
Right. You're making too much
for
sense.
moving? Anyway, the appellant's mother, Enid Carty, testified that the appellant did not mention to her that she was pregnant when they talked on May 13th or on the following days, and the appellant did not appear to be pregnant around that time. The appellant had told her the previous January that she had had a miscarriage. Enid also testified that the appellant arrived at her house in a taxi cab between 8 and 9 a.m. on May 16, 2001, took the keys to Jovelle's black Cavalier, and drove off in the Cavalier. The appellant lived now this is non-accomplice and non-testimonial evidence. It's just circumstantial evidence, I guess you call it. The appellant lived 2 apartment numbers down from the victim in the same complex. One of the accomplices answered a cell phone during the commission of the offense and stated that she was outside and asked her if she wanted it. The appellant's cell phone records reflect 7 calls made between appellant's phone and a phone that may have been used by accomplice Anderson between 12:50 and 1:14 a.m. on May 16th. Cabrera testified that the intruders broke in at around 1 a.m., and police testified they were dispatched to the scene around 1:15 a.m. The appellant was obsessed with having a baby and lied about being pregnant to many people, including her daughter and husband. In the days before the offense, the appellant told many people that she was pregnant and that her baby was due in the next couple of days. The appellant told many people that she expected to deliver a baby boy on the day before the kidnapping. On the evening of May 15th, about 5 hours before the kidnapping, the appellant told the manager at her storage unit that she had already delivered the baby and that he was home with his father. The appellant retrieved a baby blanket and 2 sets of baby clothes from her storage unit on the evening of May 15, 2001. She was driving the Pontiac Sunfire car in which the victim's body was found the next evening. Hours before the kidnapping, the appellant was sitting outside the apartment complex in the Pontiac Sunfire, and there was an infant's car seat in the back. The appellant arrived at her mother's house in a taxi around 8 or 9 a.m. on May 16th and borrowed her daughter's black Cavalier. The appellant told police that she might have loaned cars to people involved in the instant offense. On the evening of May 16th, the appellant led police to the house where the Cavalier and the Sunfire were located. The baby was found in the Cavalier, and the victim was found in the trunk of the Sunfire. The appellant had driven both of these cars in the days and hours before and after the kidnapping. The appellant was seen in possession of a gun similar in appearance to the gun found at the house on Van Zant. Ammunition fitting such gun was found in the diaper bag, which was found in the Cavalier with the baby. The appellant asked a fellow inmate to write a letter, which represented that it had been written by someone else and stated that the appellant had been set up. The verdict was rendered by the jury on February 19th and found her guilty of capital murder. The penalty phase was February 19th to February 21st. And in addition to a psychologist, Carty's mother, daughter, and one of her sisters all testified to mitigating circumstances. The jury sentenced Carty to death on February 21st, 2002. They answered yes to the special issue of whether Carty was a continuing threat to society. They answered yes to whether the evidence proved that Carty caused Joana Rodriguez's death, intended to kill Joana Rodriguez, or anticipated that a human life would be taken. And those were answered unanimously and beyond a reasonable doubt. And the jury also unanimously answered no to the question as to whether the mitigating factors were greater than the aggravators and entitled Carty to a life sentence. They answered no unanimously. They did not have to find mitigation beyond a reasonable doubt. Which is an easier burden for the defendant. They had no burden. They could deem anything mitigating. They could deem that she was a beloved preschool teacher in St. Kitts. They could say because she was a good mother to Jovel, because she was a good daughter, because she was never violent. Although I think her family didn't know her as well as they thought they did. Because she did
Yeah, they
have
never
a
do.
criminal history
Yeah.
once she came to Texas. And a
Right.
notice of appeal for an automatic appeal was filed on February 27th. Judgment adjudicating guilt on the theft of the automobile was entered on February 27, 2002, which basically found her guilty of that crime because she had violated the deferred adjudication agreement that she made with the state of Texas by committing the capital murder. On February 22nd, she was appointed another attorney, J. Sidney Crawley, and an order of indigence was also entered in an order appointing a second counsel, Kurt Wentz, for her appeal was entered on February 27th. On March 5th, 2002, Gerald Jerome Anderson and Carlos Way Williams were each indicted for capital murder in superseding indictments in new actions filed in the 177th District Court. Those were docket numbers 904461 for Anderson, 904462 for Williams. Order on motion to dismissing Combs' weapon possession charge, felon in possession of a weapon charge was entered on March 7th, 2002. So Combs, who had been charged with possession of a weapon because that weapon was found in his nightstand in his room, that was dismissed against him. I don't think he ever testified. I think Robinson is the only one who testified. Post-verdict motion, Carty filed a pro se motion for a new trial on March 19th, 2002. But a formal motion for new trial was never filed. A motion to substitute attorney of record was filed on May 21st, 2002 by attorney Dick DeGuerin. So apparently Carty was trying to retain DeGuerin to represent her on appeal, although it looks like that was never signed by the judge. DeGuerin did file a notice of appeal on March 21st, 2002. And on March 21st, the original capital murders were dismissed against Anderson and Williams, but those have been refiled on May 5th. On May 22nd, Carlos Williams was found guilty of kidnapping by a jury in his criminal case. He was sentenced on May 28th to 20 years and a $10,000 fine. Gerald Jerome Anderson was indicted for capital murder on August 1st, 2002, and yet another docket number 919665 in the 177th District Court. Order on motion to dismiss the capital murder charges against Gerald Anderson was filed on September 11th, 2001. Or was it 2002? I'm confusing myself. Sorry. And no, it was 2002.
A lot of moving parts.
And on November 22nd, 2002, Chris Robinson and Gerald Jerome Anderson each pled guilty to aggravated kidnapping. Gerald Jerome Anderson was sentenced to life, and Chris Robinson was sentenced to 45 years. And I don't have that. I don't know why I don't have Anderson's on here. My apologies, but they were the same day. On April 9th, 2003, Carlos Williams' conviction was affirmed by the Fourth Court of Appeal in docket number 0402000509CR. On May 22nd, 2003, Anderson's plea or guilty plea was affirmed on by the First Court of Appeal in docket number 01020124OCR. Mandate was issued for Anderson's case on October 3rd, 2003. Carlos Williams' mandate was issued on October 16th, 2003. On May 27, 2004, a memorandum of opinion was entered by the 14th Court of Appeal in docket number 1402012335CR, and that affirmed Robinson's conviction or Robinson's guilty plea. That mandate issued on August 13th, 2004. On November 7th, 2006, the mandate was withdrawn and reissued on March 30th, 2007 for Chris Anthony Robinson. So their convictions are final. Their sentences are final.
So that means no more appeals. They're done.
No more appeals. Chris Robinson did do post-conviction. Nobody else did. But yeah, Chris Robinson tried post-conviction, and I'm not really going to go into that. He was not successful. Okay, so back to Linda Carty's direct appeal. That was before the Court of Criminal Appeals under AP 74,295. Her attorneys were J. Sidney Crowley and Kurt Wentz. Again, there was notice of appeal filed on March 4th, 2002. Counsel was appointed on March 11th, 2002. A reporter's record was filed on March 22nd, 2002. The clerk's record was received on June 21st, 2002. Carty's brief was filed on January 22nd, 2003. Dick DeGuerin filed a motion to substitute attorney of record on August 1st, 2002, substituting for Crawley. Matt Hennessy was designated as lead counsel. So she had retained counsel of some form for her direct appeal. She was not represented entirely by public defenders. An order was issued on August 1st granting the motion to substitute. Okay, Carty's points of error in her direct appeal were points 1 and 2. The evidence of her guilt is legally and factually insufficient because it rests exclusively on uncorroborated accomplice witness testimony. 3 and 4, the evidence is legally and factually insufficient to establish that Anderson, Kasten, and Coombs were not accomplices. They also did not testify, so I don't understand why they're raising that issue. 5 and 7 are the trial court abridged her right to confrontation as embodied in the Sixth Amendment to the United States Constitution when it refused to permit defense counsel to cross-examine. Oh, maybe Coombs did testify. Robinson and Coombs alleged accomplice witnesses using their prior inconsistent videotape statements. Number 9, the trial court abridged her right to confrontation as embodied in the Sixth Amendment when it refused to permit defense counsel to cross-examine Kasten, an alleged accomplice witness, using his prior inconsistent videotape statements. So maybe they did testify. My apologies. It gets very confusing.
Yeah,
because they didn't
cite.
Yeah, because they didn't cite the accomplice testimony in their opinion, and so that's what confused me. And unfortunately, the records for Harris County aren't as complete as I wish they were, and I don't have the actual transcripts. Anyway, 6, 8, and 10 are the same violations under the Texas Constitution as those alleged in 5, 7, and 9. And then 11 is counsel was ineffective by failing to make an offer of proof of Kasten's videotape statement. The appellee's brief was filed by the state on April 2nd, 2003. The case was set for submission. There's there's reference to potential oral argument on the record, but it doesn't appear that that was actually, it may have been set for oral argument or contemplated for oral argument, and then the court decided they could decide without argument. And the case was submitted on May 28, 2003, without argument. On April 7th, 2004, her conviction and sentence were affirmed. Points 1 and 2 were overruled. The court found the non-accomplice evidence taken as a whole is sufficient to tend to connect the appellant to the commission of the victim's kidnapping and murder. Points 3 and 4 were overruled because they hold that the evidence tends to connect the appellant to the crime without relying on the testimony of any of the alleged accomplices. Points of error 3 and 4 are moot. We also note that legal and factual sufficiency reviews are appropriate for assessing the sufficiency of the evidence to support an element of the offense charged. Whether a witness is an accomplice is not an element of the offense. They overruled points 5 and 7. Our review of the record reveals that while the witnesses equivocated about making some of the alleged prior inconsistent statements, they conceded and explained most of the claimed inconsistencies. The appellant does not point to any statement by the witness at trial denying a statement that was actually made on the tape. She therefore fails to show that the videotape statements had impeachment value or that her right to cross-examination was improperly limited by the trial court. Point 9 was also overruled. The appellant did not offer Caston's videotape statement for record purposes. By failing to make an offer of proof, the appellant failed to preserve the issue for review. Points 6, 8, and 10 were also overruled because the appellant does not provide separate argument and authority under the Texas Constitution. She has forfeited these claims. Points of error 6, 8, and 10 are overruled. Point 11 was overruled. During direct examination, Caston conceded that he had lied in making his videotape statement and agreed that he did not tell the police everything he knew because he was afraid of going back to prison. On cross-examination, defense counsel questioned Caston about his videotape statement. Caston did not disagree with defense counsel's characterization of his responses on the videotape statement and gave explanations for those that were confusing or otherwise inconsistent with his testimony. The appellant does not point to any place in the record where Caston denied any inconsistency between the testimony and his videotape statement. As discussed previously, when a witness admits to a prior inconsistency, extrinsic evidence of the inconsistency is not allowed. In the absence of argument and authority demonstrating that the extrinsic evidence was admissible, the appellant fails to demonstrate that counsel's performance was deficient in failing to offer the extrinsic statement for record purposes. In addition, the appellant fails to prove how the outcome of her appeal would have been different had counsel preserved the issue. A motion for rehearing was filed. That was denied on September 22nd, 2004, and the mandate affirming her conviction and sentence was issued on October 4th, 2004. And that is the date that her conviction and sentence became final because she did not file an appeal with the U.S. Supreme Court. She didn't take a writ or anything to the U.S. Supreme Court.
So what was all the video stuff? I was like,
okay,
what's the simple explanation? Because there's a lot of words and I was trying to follow, but basically what did they say?
The questioning of Robinson, Coombe, and Caston when they were arrested was done, and those were videotaped. And apparently Carty tried to argue at trial that their videotape statements were inconsistent, or their trial testimony was inconsistent with their videotape statements. And what happens, though, is when you allege that a videotape statement or a prior statement is inconsistent, if the witness says, yes, I lied to police, and this is why I lied to police, then you can't get the prior inconsistent statement in. You don't need to get the prior inconsistent statement in because they have said, I made an inconsistent statement. And We see a lot of that in post-conviction litigation. And what they want to do is they want to get hearsay statements in, or they want to allege that hearsay witnesses could have testified at trial because the statements were inconsistent. But there's a lot more to an inconsistent statement than just saying it's inconsistent. The witness has to deny making the statement at all. So, for example, in the West Memphis 3 case, if they said to Vicki Hutchinson, did you say to Joe Blow that you were going to collect the reward? Vicki Hutchinson would have had to say, no, I never said any such thing.
Got it.
And then Joe Blow can come in and testify, yes, she did. She said she was going to collect the reward. But if she said, yeah, I told him that, but I never collected the reward, I never applied for the reward, I just thought I was going to go after it when I talked to him, and then I changed my mind, then he can't testify to undermine her credibility or veracity or statements. So, but yeah, and notice in the direct appeal, she didn't challenge the failure to advise her of consular rights in any way, shape, or form.
Got it.
Probably because her attorney saw the 2 waivers in there and found that there was no basis to challenge it. All right, so now we're at state post-conviction. And this one is a big one. And again, because Carty's ultimately alleging ineffective assistance of counsel and really going after her counsel, and her advocates are saying horrible things about him. I mean, they're saying that he's sent more people to death row than any attorney in any death penalty state, which isn't really true. And part of the reason that he's got so many clients on death row is A, they were guilty, and B, the evidence against their guilt was overwhelming, and the evidence of their guilt was overwhelming at trial, and C, because he handled exclusively capital cases. But we'll talk about him a little bit more in the second part. But we're gonna go through her claims in post-conviction, because even in initial post-conviction, her target was her trial counsel. So, her state post-conviction, she was represented by Kurt Wentz and Michael S. Goldberg of Baker Botts. Baker Botts was brought in pro bono by the British consulate or the British government. So as early as her state post-conviction in 2002, 2003, 2004, she has had other than state indigent defense counsel. In Texas, you have, it's a hybrid system. Some of the post-conviction is conducted before the state district court, the trial court, and that's the 177th District Court of Harris County, Texas. And that's under docket number 877-592A. The Honorable, at least for the initial post-conviction, was the Honorable Carol G. Davies. And also, it is before the Texas Court of Criminal Appeals, and that is docket number WR-61055-01. On May 25th, 2002, Carty's counsel filed a request for items to be included in the record for application for writ of habeas corpus and death penalty case, and that was requesting 46 specific items, including but not limited to the direct appeal record, all pretrial motions, jury questionnaires, orders signed by the presiding judges relating to defendants' motions, jury charges, statements of fact, and all transcripts. So, again, even before her direct appeal has concluded, she's already got an attorney who's developing the record for state post-conviction to give her the best chance at prevailing, I would add. And then a notice of election and reservation of time for filing application for writ of habeas corpus was filed on April 30th, 2003. An order was entered extending her time to file her writ in state court from to August 7th, 2003. Her application for post-conviction writ of habeas corpus was filed on August 6th, 2003. She claimed that she was denied her Sixth Amendment right to the effective assistance of counsel because trial counsel failed to investigate the means of the complainant's death and whether it was the result of specific intent to cause death, was denied her right to effective counsel under the Texas Constitution for the same, basically for the same reason. Each of her claims for relief is centered on the U.S. Constitution and the Texas Constitution. So basically what I'm going to do is I'm just going to allege what the reasons are, and that's going to encompass the two claims for relief. Effective assistance, denied effective assistance of counsel because appellate counsel failed to raise the issue of legal and factual sufficiency of the applicant's conviction based on the state's failure to prove that she specifically intended to cause Rodriguez's death. That she was denied effective assistance of counsel because counsel failed to investigate and adversarially contest special issue number 2. That she was denied effective assistance of counsel because appellate counsel failed to raise the legal and factual sufficiency of the jury's answer to special issue 2, which is whether she intended to cause death. That she was denied effective assistance of counsel because trial counsel failed to object to the prosecutor's improper use of an unreliable source to impeach Dr. Jerome Brown. That she was denied effective assistance of counsel because trial counsel failed to investigate whether she fit the predictive characteristics for an infant abductor. She was denied effective assistance of counsel because trial counsel failed to contest Denise Tillman's identification of applicant, even though a pretrial motion to contest the constitutionality of her identification had been filed. Applicant was denied effective assistance of counsel because trial counsel failed to adequately investigate and present available evidence on the issue of future dangerousness. She was denied effective assistance of counsel because appellate counsel failed to raise on direct appeal or therefore preserve the legal insufficiency of the evidence on special issue number 1, future dangerousness. She was denied effective assistance of counsel because trial counsel failed to investigate and present available mitigation evidence, which was basically just other siblings testifying to the same things our mother, sister, and daughter testified to. She was denied effective assistance of counsel because trial counsel failed to investigate and develop that an applicant was a citizen of another country and subject to the protections afforded to her by the Vienna Convention on Consular Relations. That she was denied effective assistance of counsel because trial counsel failed to present available evidence rebutting the origin and truthfulness of Sarah Hernandez's testimony. That she was denied due process of law as decided in Apprendi versus New Jersey, exposing her to cruel and unusual punishment in violation of the 8th Amendment and in violation of the Texas Constitution. That she was denied effective assistance of counsel on direct appeal when counsel failed to raise the trial court's error in overruling applicants' pretrial motions concerning the assignment of a burden of proof on the mitigation issue. And finally, that she was denied effective assistance of trial counsel by the cumulative effect of counsel's errors through trial. A motion for evidentiary hearing was filed also on that same date. It was denied on October 6, 2003. A second application for post-conviction writ of habeas corpus was filed on December 8, 2003. And I compared these two documents, and I don't see any difference or distinction between them. So I don't quite understand why that was done. I will look into
Was it just
it.
a waste? Was it just to like clog the corpse?
I don't know. I honestly, I looked at them. I compared them side by side, page by page, and I will look at them again because maybe I just missed something when I'm working on the notes for part 2, and I will see if I can see what the distinction might be for that. I'm making a note of that now so I don't forget. All right, so now this is I'm going to cite some of the state's evidence and some of Carty's evidence in support of this post-conviction application. And some of it, I guess, like to develop a more complete picture. So Guarino gave an affidavit to the state on January 16, 2004. Contrary to later arguments by Carty, when you say your trial counsel was horrible, your trial counsel does not have to sit back and say, oh, well, attorney-client privilege, I can't say anything. When you say your trial counsel was horrible, your trial counsel can defend himself. And that's across the board in any state, any jurisdiction. He states that he was appointed to represent Linda Carty on her charge of capital murder on September 18, 2001, after Parnham withdrew. He says Carty refused to speak to him or her co-counsel, Wendy Akins, because she insisted on hiring her own lawyer. Carty did not speak to them from September until the end of jury selection. Carty was the most uncooperative defendant he had ever represented in a capital murder case. And believe it or not, after looking at her interviews, I can see this. I totally believe it. I totally believe that because she was going to hire counsel, she would not talk to him. And she would not tell him anything.
Yeah, she seems nuts. I mean, obviously she's nuts, but she seems like even nuttier than nuts.
No, she's not nuts. She's cold. And she's manipulative. And she's out to get what she wants when she wants it. There's no mental deficiency here. Maybe antisocial personality disorder, but as I've said many, many, many times, personality disorders are not mental illness.
Right.
They are a flaw in the personality that develops somehow, some way in, child development. After jury selection was over, Miss Akins and I visited Miss Carty in jail and essentially bribed her with chocolate bars to speak to us about the case. At that time, Carty told us the circumstances surrounding her stay at the Hampton Inn Hotel and the items found in her room. We filed a motion to suppress evidence that was recovered in the hotel room and were successful in that motion. Carty still continued to state that she was hiring other attorneys and again stopped communicating with us during the trial. The primary evidence against Carty was testimony of Chris Robinson, who had cut a deal with the state for a lesser sentence. There was also testimony by 2 other individuals who were admitted drug dealers and generally undesirable people. Carty never admitted involvement in Joana Rodriguez's death or the abduction of her baby. Our strategy was to cast doubt on the state's witnesses' testimony and to show that they would say whatever was necessary to save themselves. If we got to the punishment phase, we wanted to show that Miss Carty did not have a violent past, would not pose a threat in the future, and that she had overcome adversities in her life through the testimony of Dr. Jerome Brown and her family members. I reviewed Dr. Schroed's extensive report and did not feel it was necessary to meet with him. I knew that Dr. Schroed's conclusion was that Joana suffocated. I did not hire a forensic expert because I thought it would be more effective to use the state's expert to cast doubt that Joana's death was intentional. During cross-examination, Dr. Schroed said that Joana's death could have been caused by either the positioning of her body in the trunk, tape being placed over her mouth, or the bag placed over her head. Dr. Schroeds also said that the bag could not have been placed on Joanna's head last, which directly contradicted Robinson's testimony. If possible, I think it is more effective to further a defense case through state's witnesses as opposed to hiring defense experts. I also argued in closing that Dr. Schroed's conclusion conflicted with Robinson's testimony and that the death was unintentional. The focus of the case was whether Carty was involved in the kidnapping and intentional killing of Joanna. To that end, we focused on showing that Carty had nothing to do with Joanna's kidnapping and death. At punishment, Dr. Brown's testimony was that Carty did not meet the profile of a dangerous person and that none of his test results showed her capable of committing such a crime. The testimony of family members showed her to be one who complied with the rules and was nonviolent in nature. And that's why I say they didn't know her. And that she wasn't violent. This was cold and calculated. It wasn't violent.
Yeah, it wasn't like she
It
was
wasn't
doing it
a
herself.
sudden reaction. It was
Right.
cold and calculated. And it was because Joanna could identify her. And Joanna had
Exactly.
seen her.
Right.
I'm not going to go into some of these things because it's not related to Carty. Carty never told me about the sexual assaults because she alleged she was sexually assaulted, became pregnant, and gave the child up for adoption while she was going to the University of Houston. Wendy Akins pointed out in closing argument in the punishment phase of trial that the sexual assault and its consequences could be considered mitigating evidence. Carty did not provide me with the names of people who would testify on her behalf. Carty did not want her family to testify, but I approached them anyway because I thought their testimony was important. This is important. I was forced to obtain a writ of attachment to secure Carty's daughter Jovelle's testimony. We took the step after Jovelle, who was under subpoena, did not appear in court as she had promised. Carty's family told the jury that she was a kind and loving person who taught school before coming to the U.S. The jury was made aware of the fact that Carty raised her daughter on her own without any assistance and encouraged her daughter to have a relationship with her father. Carty's family asked the jury to spare her life. 2 police officers testified that they had worked with Carty as a CI for a number of years and enjoyed a cordial relationship with her. One testified he found it hard to believe Carty would be involved in this type of crime. I did not subpoena Carty's jail records because I did not want to open the door to the state offering testimony that Carty threatened another inmate. I made it abundantly clear to the jury that Carty was an intelligent woman who worked hard, and I did not believe that her college records would make that point any stronger. I did not know that Carty was a British citizen until an individual working with the British government on Carty's behalf contacted me. At this point, Carty's case was in the appellate stage. Carty told me she was born in St. Kitts, but that she was a U.S. citizen. Aside from that, I am aware that there is case law stating that the Vienna Convention is not a vehicle by which to suppress evidence, and emotions such as that would not have been successful. I was aware of a witness in the Harris County Jail who had some information about Sarah Hernandez. As I recall, the witness would have testified she heard Hernandez tell another inmate that Hernandez stole notes from Carty and that she had information on Carty. The witness also said that Hernandez told another inmate that if she testified against Carty, her sentence would be reduced. The witness's testimony had nothing to do with the letter Hernandez allegedly wrote for Carty, and Hernandez was already serving her prison term when she told the DA's office about her alleged involvement with Carty. On cross-examination, I was able to get Hernandez to admit that a letter from the prosecutor to the parole board might help her get early release on her 5-year prison term. I also pointed out that the jail monitored all inmate mail. Finally, I attempted to ask Hernandez about the fact that her aggravated robbery charge had been reduced to robbery. So that was pretty much Guerno's affidavit. The state filed its answer on February 3rd, 2004. Carty filed a motion to recuse the judge, basically because the judge denied her motion for evidentiary hearing without notice or hearing. That that basically there were contested issues that the court wasn't aware of at the time it denied the motion, and basically that denying the motion for evidentiary hearing denied her due process of law and evidence bias against Carty. The judge filed an order declining to recuse on March 3rd, 2004. Carty withdrew the motion to recuse, but the presiding judge on May 13th, 2004, issued an order officially denying the motion to recuse. So that was Judge Olin Underwood. Notice of appearance by Michael Goldberg was filed on May 28, 2004. On September 7, 2004, there was an affidavit filed by a woman named Lisa Casciola stating that State's Exhibit 68, described as bandage scissors, were not capable of cutting human tissue. Now, this is one of those issues that came in at trial. Garano argued at trial that the scissors couldn't have cut human flesh because the allegation was that Carty had made statements that she would cut the baby out of the bitch.
Oh.
And alleging that these scissors were the implement that she obtained to do so. However, what Carty's defenders don't take into account, maybe she was stupid and bought something that she thought would work that wouldn't have worked, ultimately. Maybe she intended to use a knife to cut the baby out of the bitch.
Oh.
You know, I mean, it's like, don't go into this minutia and say, well, these aren't the right scissors to cut them out. So the state was lying to the jury when it said those scissors could be used.
Yeah, that's crazy.
What's really weird is that in the appellate documents, the scissors are described as surgical scissors. And I did find a picture of the scissors that they have an angle, but there is a point on the upper blade of the scissors. The bottom blade may be rounded. It's kind of hard to tell. There's like a flash or some defect on the plastic that make it kind of hard to see. But these don't look like rounded bandage scissors, completely rounded bandage scissors. And interestingly, there isn't a picture of this exhibit attached to the affidavit. But the problem with this argument is that this is something the jury could have observed for themselves. This is an argument that Jerry Garano raised to the jury. So you having a nurse come in and say, oh, these scissors couldn't have been used to cut somebody open is not going to cut it in post-conviction. It's not new evidence. It's evidence you could have brought in at the time of trial. And it's something, again, the jury could have observed for themselves and made their own decision. And doesn't take into account the fact that maybe Linda Carty was stupid. And she didn't know what kind of scissors would be necessary to actually accomplish what she wanted to do. And again, it's irrelevant too, because she didn't have to cut Ray out of Joanna's stomach because Ray had been born before she sent Robinson, Williams, and Anderson into the apartment. An affidavit was filed on behalf of Jose Javier Corona on September 16, 2004. He stated he did not want to be involved or testify at Carty's trial. Carty's counsel did not explain spousal privilege or that he had the right to refuse to testify at Carty's trial to him. If he'd been informed of marital privilege, he would have refused to testify. He was not asked to testify at the sentencing phase. Had he been asked to testify, he would have testified that Carty did not deserve the death penalty, and he does not believe she's an aggressive person or a threat to society. Of course, you must have thought she was kind of aggressive when she pointed a gun at you, son. But okay. And actually, the funny thing is, Carty could have raised marital privilege when Corona testified, because it can be raised by either spouse, the defendant or the spouse being compelled to testify. And I don't know that Corona was actually compelled to testify.
Right, got it.
But she could have sought to suppress his testimony even if he wanted to testify, because it's a privilege that works both ways.
And she did not, though. She did not.
And she didn't. She never did. And she's trying to say her attorney should have told him he could refuse to testify. An affidavit of Linda Carty, who was a consular official of the United Kingdom based at the consulate in Texas, basically saying, oh, we would have helped her if we'd known. And then Linda Carty's affidavit, and I include this, and I'm going to read this, all 22 points, because it just shows her absolute freaking gall. And her lack of making sense. So she signed this affidavit on October 22nd, 2004. First, she says, I did not read the stack of papers I was given to sign at the time of my arrest. I did not check the box indicating that I was a U.S. citizen. Had I known of my right to consular assistance, I would have invoked it and refused to speak to anyone until I was in contact with my consulate. I was never advised of my right to consular assistance, which is untrue because it's on one of the statutory warnings that she got from the magistrate. Had I known of my right, I would have willingly accepted the assistance. I hired Parnham with the help of my family, who was raising money for my defense. My family wasn't able to raise the money in time, and Parnham withdrew. Garneau was appointed on September 18, 2001. At that time, I was still trying to raise funds to hire my own attorney. I communicated this to Garneau. He never sought a continuance on my behalf. If the trial judge had delayed the trial for a month or two, my family would have been able to raise the necessary funds to hire a defense attorney. I paid $50,000 to Matt Hennessy to represent me on direct appeal. I first spoke to Garneau 2 weeks before voir dire. He came with Akins, but only spent 15 minutes with me at the Harris County Jail. I did not have time to explain the details of my case to him. He said he didn't have time to prepare for the case because of his daughter's wedding. He sent an investigator, John Castillo, to meet with me briefly on December 11th, 2001 and December 14th, 2001. I feel there was a complete breakdown in communication, and trial counsel did not adequately prepare to represent me at trial. Garneau and Akins never sought to withdraw as my defense counsel. I never consented to my trial counsel, Jerry Garneau or Wendy Atkins, talking to the state or giving the state an affidavit regarding their representation of me. Garneau's claim that he bribed me with chocolate bars is false because I am allergic to chocolate. All right, Linda. On the 29th of October, 2004, and I imagine there was some mighty arm twisting going on. I imagine poor Mr. Garneau was threatened, probably with all kinds of harsh and nasty consequences of providing an affidavit to the state, even though there was nothing wrong with it. He gave an affidavit on Carty's behalf. He admits he did not contact Corona prior to trial. He admits his investigator did not contact Corona prior to trial. He admits that Corona's testimony hurt Carty's case. He admits he never attempted to inform Corona that he had the right as her husband not to testify. He did not ask him to testify in the punishment phase. He did not speak to Anita Carty until after the guilt-innocence phase had concluded. He did not speak to Linda's sister, Iceland, until the day before she was to testify. He did not contact her brother, Boyce, or her sister, Sonia or Verna. He did not contact anyone in St. Kitts. Had he known the former prime minister and deputy prime minister were ready and willing to testify, I would have used them, and I believe they may have had a strong influence with the
Why
jury.
would the prime minister testify on her behalf?
Well, Linda apparently was a member of a People's Party, which I take to be somewhat of a communist influenced party in St. Kitts.
Got it.
And that's apparently the government that took over from Britain when St. Kitts gained its independence. And they gave affidavits that they were willing to testify for her. He did not obtain her permission to submit the affidavit previously submitted and never spoke to her or any of her attorneys regarding preparing or providing this affidavit. And he said he met with the Assistant DA, Jane Scott, who typed the affidavit. On November 1st, 2004, Carty and the state each filed their proposed findings of fact and conclusions of law. On the same day, Carty filed an additional further response to the respondent's original answer. And at this point, she raised additional issues, basically arguing that the trial court's errors violated her constitutional and substantive rights and prejudiced and harmed her, in that the trial court improperly defined capital murder, improperly instructed the jury on felony murder instead of capital murder, and that this was harmful error, that they improperly instructed the jury as the meaning of the term criminal acts of violence included in special issue number 1, and properly instructed the jury on accomplice witnesses, improperly, that because there was no evidence of specific intent, the trial court should not have allowed the case to go to the jury. The prosecution's errors violated Carty's constitutional and substantive rights and therefore prejudiced and harmed her, in that the prosecution's opening statement about all sorts of baby items found in Carty's room at the Hampton Inn was a flagrant misstatement of the evidence. The prosecution failed to inform Carty's husband that he had the right to invoke spousal immunity. The prosecution misstated the law on accomplice testimony and corroboration during their closing argument. They erred in promoting a theory of Carty's specific intent that was not supported by the evidence, and that they violated her Sixth Amendment rights by secretly putting together an affidavit from Carty's trial counsel to use in opposition to Carty's request for habeas relief. That she was also denied her rights to effective trial counsel, in that they were inadequately prepared and failed to properly investigate her case, that they provided ineffective assistance during voir dire and through inadequate and inflammatory questioning of potential jurors, that they failed to object to the court's improper definition of capital murder, criminal acts of violence, which tainted the entire jury, and that they failed to object to the prosecution's opening statements that were subject of a motion to suppress, that they provided ineffective assistance to counsel because they failed to investigate the means of Joana Rodriguez's death and whether it was the result of a specific intent to cause death. These are basically raising, and I'm gonna stop right here. They raise a lot of new issues that weren't raised or were raised inadequately in the initial pleadings, and they also, supplemented their arguments about the Vienna Convention, etc., so on and so forth. So that is that was filed. No action was really taken. The state didn't even address it. I think because it was raising new issues, or raising them differently than how they were initially presented and how they'd been presented all through the course of post-conviction and direct appeal. The court entered findings of fact and conclusions of law on December 2nd, 2004. And basically, I'm not going to go into the factual findings because they are legion. It's just
I've
too
seen
much.
a lot before, but she may set the record for just randomly raising crazy issues.
Well, it's the shotgun defense. Okay. Oh, when you mute, you disappear. Interesting. I'm not going to go into all the findings. One of the things that the court found, though, on the Vienna Convention arguments, because these factor heavily into the media claims about Carty's case, The applicant was given statutory warnings on 2 occasions by 2 different judges that applicant informed both judges that she was a U.S. citizen. One judge noted per defendant she is a U.S. citizen, and that the applicant told trial counsel she was a U.S. citizen born in St. Kitts. So basically, there isn't really, the Vienna Convention doesn't allow you to negate a conviction if the terms were not followed. And there was a lot of, in early 2001, 2002, 2003, there was a lot of talk about that, and we might go into that on another case with an execution where the guy was a Mexican national, but he'd been living in the country illegally since he was very young. And he told people he was a U.S. citizen, but in reality, he was a Mexican national illegally living in the country. And they tried to use the Vienna Convention arguments to have his sentence commuted from death to life. And it was not successful, and he was executed by the state of Texas. So we might look at those arguments and those claims, and they'll be a little bit more they'll be addressed a little bit more in depth, maybe in part 2, but we're not going to go there now. But it basically, the Court of Criminal Appeals held that a violation of the Vienna Convention, a treaty that gives arrested foreign nationals the right to contact their consulate, does not require the suppression of a defendant's confession. It does not negate their conviction. And then also basically found against Carty on all grounds. But I will go into the conclusions of law, because those are important. Did I skip them? I'm sorry. Okay, sorry. Conclusions of law. Okay, cause of death and applicant's intent. Counsel are not ineffective for choosing the reasonable trial strategy of attacking the assistant medical examiner through cross-examination rather than hiring a defense expert and eliciting potentially beneficial testimony concerning the applicant's intent during cross-examination. Counsel are not ineffective for choosing the reasonable trial strategy of casting doubt on the state's witnesses through cross-examination rather than hiring a defense expert. Thus, the applicant fails to show deficient performance, much less harm under Strickland. Objection to Brown's testimony in response to trial counsel's timely objection that was sustained by the trial court. The prosecutor was prevented from reading aloud portions of a study done by the National Center for Missing and Exploited Children. Thus, counsel cannot be considered ineffective for lack of objection, i.e., defendant received all relief requested when her specific objection was sustained. Applicant fails to show that counsel are ineffective for not objecting to the prosecutor's proper hypothetical involving a hypothetical defendant to a defense psychologist. Counsel are not ineffective for following the reasonable trial strategy of attempting to show applicant was not involved in the kidnapping or death of the complainant by trying to undermine or discredit state's witnesses through cross-examination. Applicant fails to allege and prove that the pretrial identification procedures in the instant case were impermissibly suggestive. Thus, the applicant fails to show ineffective assistance of counsel based on the lack of pretrial motion to suppress identification, i.e., counsel are not ineffective for failing to assert meritless pretrial motions that would not have changed the outcome of the case. Future dangerousness. Trial counsel cannot be considered ineffective for an alleged failure to investigate and present mitigating evidence and evidence of lack of future dangerousness in light of counsel's investigation and presentation of thorough punishment evidence, including testimony concerning the applicant's family background and support, positive personal characteristics, positive activities, work ethic, and her parenting abilities, and expert testimony concerning the applicant's lack of future dangerousness. Vienna Convention. Let me take a sip of my Diet Coke, because this one's going to be long. Buckle up, folks. Counsel cannot be considered ineffective for not advancing, as part of counsel's motion to suppress applicant's statement, the claim that applicants' rights pursuant to the Vienna Convention were allegedly violated in light of applicants' repeated assertions that she was a United States citizen and the lack of an individual's standing to enforce the provisions of the Vienna Convention. Treaties operate as contracts among nations. Thus, offended nation, not individual, must seek redress for violation of sovereign interests. Counsel are not ineffective for not advancing the meritless argument that any violation of applicants' rights under the Vienna Convention requires suppression of her statement. Violation of the Vienna Convention Treaty, giving arrested foreign nationals rights to contact their consulate, does not require suppression of defendant's confession. Counsel's performance is measured against the law in effect at the time of trial and cannot be based on unsettled law. In the alternative, applicant fails to show harm based on any lack of notification to the British consulate concerning her arrest for capital murder. Applicant was provided with the effective legal representation upon the applicant's request, and applicant's constitutional rights were safeguarded. In order to be entitled to habeas relief, defendant must plead and prove that complained of error did in fact contribute to her conviction or punishment. They basically found not rebutting Sarah Hernandez's testimony with a witness who didn't have anything to do with the letter Sarah Hernandez was asked to write was not ineffective assistance of counsel. And then sufficiency of the evidence regarding intent and future dangerousness. The court basically found that because applicant's habeas claim presented in the guise of an allegation of ineffective assistance of appellate counsel for not prosecuting on direct appeal sufficiency of evidence claims concerning intent and future dangerousness is actually an attack on the sufficiency of the evidence. Applicant's habeas claims are not cognizable in a writ proceeding. In the alternative, appellate counsel cannot be considered ineffective for choosing not to advance on direct appeal meritless sufficiency claims. Appellate counsel does not have a constitutional duty to raise every non-frivolous issue. Courts cannot second-guess appellate attorney's professional judgment to brief only stronger points of error. The applicant offers no proof that, but for appellate counsel's alleged errors, the results of the proceeding would have been different. Appellate counsel cannot be considered ineffective for not advancing on direct appeal the meritless claim concerning lack of appellate review on the sufficiency of the evidence of the mitigation issue, an issue that the Court of Criminal Appeals has repeatedly addressed and rejected. Burden of proof on the mitigation issue, again, that's been repeatedly addressed and rejected by the Court of Criminal Appeals, and so not raising the issue cannot be found to be ineffective assistance of counsel. On December 2nd, 2004, the trial court ordered that the record be prepared and sent to the Texas Court of Criminal Appeals to review the trial court's findings and recommendation that relief be denied. That was received by the Court of Criminal Appeals on January 12th, 2005. A miscellaneous document of some sort was received. I'm not quite sure what it was. And on March 2nd, 2005, the Court of Criminal Appeals entered an order that stated applicant presents 30 allegations in her application in which she challenges the validity of her conviction and resulting sentence. The trial judge entered findings of fact and conclusions of law. The trial judge recommended relief be denied. This court has reviewed the record with respect to the allegations made by applicant. We adopt the trial judge's findings of fact and conclusions of law. Based upon the trial court's findings and conclusions and our own review, the relief sought is denied. Wentz, on March 17, 2005, filed a motion to withdraw as attorney of record and a notice of appearance for Baker Botts for the purpose of federal habeas. And because Baker Botts was going to take over representing Carty in federal habeas, And on March 17, 2005, Wentz's motion to withdraw was granted. Baker Botts confirmed that it agreed to represent Carty in her federal habeas proceeding, and that was signed by the trial court judge, Devin Anderson, who was the presiding judge by that time, and it was signed by Michael S. Goldberg, by permission by Marianne Lyons at Baker Botts LP. So that is Linda Carty's crime pretrial trial, accomplices, and direct appeal and state post-conviction. And you can see why this has to be 2 parts. You back, Kyle? Kyle, you dropped. Oh my goodness. Where did Kyle go? Well, it looks like Kyle is having a technical difficulty with StreamYard. This is a new platform, but I think it's good because we didn't have any "you have lost connection" errors during the course of the show. So that's a positive thing. But it looks like Kyle has dropped, lost internet connection, having problems, technical difficulties with his computer. He's muting himself and unmuting himself. Oh, wait.
Can you hear me?
Yes, I'm so sorry. Somehow you
I was
dropped
literally
off
clicking.
the
It showed me unmuted. I was literally back and forth, like toggling. I was like, what is going on? I don't know if it was a slow thing, but yeah, I was talking about Baker Botts.
Oh my God. No.
I must be magically muted.
What happened, for some reason, you dropped off the stage. I don't know why.
Weird.
But you dropped off the stage, and I'm new with StreamYard, folks, so I'm really sorry because I didn't recognize that problem.
Because I was trying to not cough on the microphone. I had a couple of coughing and a sneeze, and then
well, maybe you did something that made you fall off the stage.
It was I'm sure. I'm pretty technically idiot.
So, well, what were you saying? Please.
No, I was just like,
what were you saying about Baker Botts?
Baker Botts, like, that's not messing around. I mean, you talk about bringing a nuclear weapon to a knife fight. Goodness, I mean, I don't know how she was able to talk them into. Well,
the British government got them to come in pro bono, and they came in pro bono, I think, during the final stages of her direct appeal, and they definitely came in and worked on her state post conviction. So, I mean, yeah, they're not lightweights.
No.
So,
well, you certainly, I mean, understand. I mean, I always said you since our very first case, you certainly understand just the legal system and all the time and money and appeal. It's remarkable to me. I mean, no matter, as long as I've done this and we've talked about it and know stuff, it's shocking to me, all of the amount of work that goes into all of these appeals and stuff. Mm-hmm. I'm no value judgment. It's just shocking. Like,
yeah. And it's a shame that a lot of times the media, it only reports half the story. It reports the advocacy for the convicted person, and it ignores the state's position, the state's counter arguments, the evidence that refutes the claims made by the advocates for the convicted person. And it also ignores the fact that the courts consider both sides and what the courts have found. You know, they're still arguing Vienna Convention, as though that's the magic bullet that's going to get her off death row at the least.
Well, yeah, because I mean, there's not even a dispute that she's an American citizen, right? Like, it's not even does anybody even question that?
Well, you know, that's what she told the magistrate. That's what she told her attorney at trial. Yeah,
I mean, that seems like a pretty easy thing to verify.
why she's allowed to say, "Oh no, I never told them that," and that becomes a be all end all. Because that's what she's claiming. She's claiming I never told anybody I was a U.S. citizen,
But it
and
doesn't matter who she told, right? I mean, either
yeah.
she is or she isn't.
Well, the problem is that now they're claiming she isn't, never was.
But isn't that pretty easy to verify? Like that, I mean, I realize
I
it's
think
our
so. I
government, but
mean,
like that seems like that's not
yeah.
a
I mean,
difficult thing to figure out.
but they're hoping that nobody does that homework. And
Right.
most of the media doesn't do the homework because I think they've got her DEA records, and her DEA records say she holds dual citizenship.
Yeah.
So,
Well, I mean, the thing is, like you said, with the media coverage, it's even getting scarier because now we're actually seeing this kind of Orwellian trend where, the regime media just actually goes back and rewrites history and pretends that things
mhm,
that, edit stories, etc. So
mhm,
it's
yeah.
crazy.
And like saying Joana Rodriguez was white
Yeah.
when
Yeah,
she
exactly.
was a Mexican
Well, it was just like, yeah, what was the
national
George Zimmerman when the media
Hispanic.
media came up with the new white Hispanic term in the George Zimmerman case.
Well, I mean, I've said this, and I'll say it again. I have known African American people who are incredibly prejudiced against Asians, Hispanics, and and Middle Eastern people. Virulently, violently prejudiced, biased. I have known, Korean people are a lot of times very prejudiced against African Americans and Latinos. Racial prejudice is not unique to white people. They are not
No,
the only people that can be prejudiced.
no, it's
Um,
a yeah. Unfortunately,
yeah,
it is a universal reality of the human
yeah,
experience.
and so it's not, George Zimmerman, even though, and actually, I gotta say, the Argentinian and Peruvian people that I have known personally, they do not consider themselves Latino or Hispanic. And if you call them Hispanic, they will cut you because
Well, yeah, I mean,
they
that's the
are
funny
better
thing
than
when you,
Central Americans.
yeah,
They're South American. They're
when you
not.
get into the details of the,
Mhm.
yeah, to your point, the Latino pecking order, yeah, call a
Yeah.
Cuban a Puerto Rican and see what happens.
Yeah, call a Cuban Puerto Rican, they will cut you. Call a Puerto Rican a Cuban, and they'll cut you. And call either one of them Mexican, and they'll beat the crap out of you.
Yeah, exactly.
You know? It's like Mexicans are the only ones we don't care if they get it wrong. We don't care. I don't care if they call me anything, whatever.
But
But
yeah, it's weird that they try to like, oh, it's okay, she's white, so it's okay that you
mhm,
killed her.
mhm. Yeah. I
It's so
worked with a
strange.
woman who I called her a Latina, and she's like, "I'm not Latina. I am not Latina." It's like, "You're Mexican," but she's not native indigent. She's pure Spanish
Yeah.
heritage.
Well, and it's like we're totally chasing a rabbit now, but it's like the
So,
whole, yeah, kind of trying to create these. I think it was an effort by the Ford Foundation to kind of try to create these monolithic, like to kind of take, like you see it a lot now with all of a sudden anybody like this whole, like all of a sudden in like the last 5 years, the term Asian, like we used to call folks like Indians or Asians or Pakistani, and now everybody's suddenly Asian who like lives east of Vienna. And it's like, I
well,
don't know
actually, no, but
if that
that
was
is
the case a few years
it's
ago.
actually Pakistan, Afghanistan are not in the Middle East. They are in Asia. They are in Southern Asia.
Oh yeah, no, totally. But
India
I'm just saying, like
is
we used to always like w- people didn't group everybody
well,
that lived east of Vienna as Asian.
I think it's the fact that we narrowed our focus of Asian to Chinese, Korean, Japanese. And Southeast Asian, Vietnamese, Cambodian, Laotian. And then Southern Asia and Southwestern Asia, we just kind of didn't have any, we didn't have, the term Oriental for many years was used to describe people
Right.
when Oriental is meant to describe objects
Correct.
from the Orient.
Just like my one of my favorite company. We always think about Oriental, we forget about Occidental, which is the Western, which Occidental Petroleum. Now I'm having a senior moment on who owned Occidental Petroleum, but one of the famous rich people in California.
I don't remember.
But I digress.
Yes. Well, your homework now is to look up all those big oil companies and all those big families and put the family with the oil company you're working next week, correct? You're out of town.
Yeah. No, next weekend we'll be out of town.
Okay. Next weekend you're out of town.
Oh yeah, Armand Hammer. That's who owned Occidental Petroleum.
So
always a weird. Always thought like he's named after the baking soda.
Oh, Armie Hammer's the actor Armie Hammer's relatives?
Yeah, his grandfather, I think, is the one that started Occidental Petroleum. That's where they got all their money.
Well, that's good because he got money now that nobody will hire him to act anymore.
Exactly.
Although I don't know. I mean, I don't think it's fair to cancel somebody for their private life.
Yeah, that's a whole other episode, right?
Yeah, I know it's not fair, but it's going to happen more and more. It's a shame Phil Spector didn't live long enough to be canceled. All right. Well, let's go ahead and wrap up. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLN. Kyle and I will return in 2 weeks for episode 12, State of Texas versus Linda Anita Carty. In part 2, we'll continue our look at Carty's case, including her federal habeas claims, subsequent state post-conviction claims, and her attempt to raise new claims in federal court. Until then, have a safe 2 weeks and stay safe.